production and automation, production goes down and automation goes up, the value of knowledge goes up as well. So basically, you know, you take companies like, say, Facebook, and essentially they're a knowledge company. That is where their value lies. So, in the words of Peter Thiel, competition is for losers. So if you have a piece of knowledge, how do you keep everybody else out? And there's a variety of different tools for doing that. A technical solution to a technical problem. It's kind of a functionality for stuff under the hood. You've design rights for how something looks, and you have trademarks, which is a badge of origin. It's like you can have an exclusive sticker that you stick on your products that will be made. There's other ones, there's copyright and there's database rights as well. But these are complex tools, and the process to getting monopoly rights granted is a complex procedure. So when you're converting, or when you're trying to protect an idea so that you have it exclusively to yourself, you know, you're well advised to use an intellectual property advisor. Now, today is a lucky day in that there's a lot of them around, and there's a lot of familiar faces there. There's a lot of So basically, I'm kind of coming to the end of my little segment here. The take-home messages I want you to have is that you need, like, I think I'm preaching to the converted here. You have to have an IP strategy. The IP strategy has to be thinking about how you harvest information, how you identify the valuable knowledge, and how you're going to protect the valuable knowledge, and then how you're going to use it. It has to align with your business strategy, and you should use all the tools at your disposal. So you shouldn't just concentrate on one IP right, you should use everything. There's a broad suite, it's not a one-size-fits-all. So, I hand over to David again.
Good morning, and thank you for the invitation and for the introduction. I think I'm going to continue what Richard was talking about harvesting that knowledge that is generated in your companies, because this forms a large part of your increase in valuation in SMEs, startups, and companies like that. And from a practical perspective, after being involved in SMEs and startups for a number of capture that, how do you harvest that knowledge? And because you don't want it to become an extra job, an extra chore to your staff, because in high growth businesses, as you know, everybody's busy doing all sorts of things. You don't want to add to the workload anything that is not kind of necessary. And I think there, what you can do is obviously to train people to have them understand the system, how the IP system works, what is IP, what is not IP, and how it is actually captured, that it's not just kind of filing a patent application, it's a lot more than that, and why it needs to be captured, and how it can be captured. It can be logbooks, can be notes, emails, can be discussions that are captured in some way. And I think the best way to put that kind of policy of capturing all of this is for the senior management, or at least the senior line management, to actually show people they need to do that. They need to lead by example, and everyone needs to see that that's being put into action, and also where that leads, and then that has led to this kind of increase in the portfolio, or that okay, we have now decided that after these discussions that these guys have had over here, we're going to file a patent on this, and then once that's granted sometime later, then that's also people are told. So I think the key message in terms of how do you incorporate this knowledge harvesting into your culture is training, making sure that people understand the value of that. How does that fit into this broader business growth? And then you need to tell them, and they need to see exactly how that's kind of how it happens as it's happening. So if just kind of left in isolation in a little bubble, then people will not really kind of embrace that. I think that's my experience, and that's worked in places that I've been a part of. So I think I can hand it over back to Aaron.
Thank you very much. And I'd ask Paul Stoney, EVP of Products and Audio, to take a step.
Good timer myself. I think an awful lot of companies that I've worked with and advised, and I think in general in Dublin in the internet software business, are seeing a lot of pressure for competitive differentiation. And what they're finding is brand is super important, right? So the brand of your product is an asset, and how you build that brand is part of your IP portfolio. And I was delighted to see it on the map earlier. So I'd just like to take a moment to say we at Webio really thought about this from the get-go. We thought about our brand name, short brand for easy to recognize. It was web input output, so it was easy to remember. We took a positioning in the marketplace where we invented this positioning called conversational middleware, which didn't exist anywhere, so we're the world leaders here, right? We are number one in the world. And we're going after that position, and that's all about how we build our content and what we speak about and what we put out there in the world. That builds that SEO against that position. And then we said, okay, you know what? We're too poor. Well, we can't go to all these conferences across the world that are starting to bubble up. What we'll do is we'll run our own. And that was just a genius stroke and crazy at the same time. So we started up a conversational interface conference in Dublin called ConverCon, and we invited Facebook and Google and Microsoft and all these guys to turn up at our conference and talk about the future of this industry, which of course gave us an incredible brand platform, because now we're associated with all these big companies and all these big brands, and people are going, well, they must be a very big company. They're on the stage with all these very big guys. So I think that this is just an example of outcomes. You get much bigger outcomes. And there's this idea of clustering and this kind of sense of energy you get when you get momentum and you get a benefit from the thing you've just done. So you've completed something, there's a burst of energy, and then an outcome from your investment in intellectual property. But also thinking in non kind of add to each other to help you get outcomes. So I think that you can build good intellectual property, good brand positions by being thoughtful, by being brave. We have this idea that there is data in conversations. So when you're interacting with customers and they're interacting with you, there's data being produced in that interaction. And so conversational interaction is more than just facilitating conversations. It's this whole new area of, this is going to give us a lot more detail on personal interaction than you've ever had before. And so we've built an IPR path going forward around how do you use conversational interaction to make conversations complete more effectively. So we've an outcome in mind that we're going to build specific assets that will be valuable and, again, things that may be licensable going forward. And we also try to build from the bottom up to be architected for API, which is Application Program Interface, so they want to be part of a network of assets and companies. And after a while, if you've done this well, what happens is you stop with the need to keep pushing and I don't know what the word is, hustling to make things happen in the world. There's a moment where it kind of turns and it becomes, you move from push to pull. So instead of trying to ring people up and say, I'd really like you to speak at our conference, they're ringing you up to see if they can speak at your conference because they've heard that it's really good. And people are asking you to go to talk to them about what conversational could change their companies because they've heard that you know what you're talking about. So that is that much vaunted idea of you go from push marketing to pull marketing, and having a great asset is what pulls those people to you and makes it like far cheaper to find opportunities that you can exploit. So that's my 5 minutes. It can be done. You need to be thoughtful. You need to be programmatic about it.
2 words, please.
So the excuse today to not have patents is much less than it was back then. I can forgive myself and say, I'd already talked to Joe Doyle and we were aware of it, but the fault was entirely mine. I had not launched, as the CTO of a well-funded venture-backed company, a full patent strategy. And we paid the price for that. If you don't build an arsenal and your town gets attacked and the first bullet whizzes by your head, there's no time to build a patent portfolio. So a couple of thoughts. The first one is, if you're entering the US market, you have to have patents. And I've helped a lot of startups, some of them are in the room. I see startups filing one patent, but they really don't have a patent strategy. So one of the things that's super important is, if you're going to enter the US market and you have novel technology, you have to have that protected, because what will happen is others, and I would put, there's a couple of nations on the planet that are particularly good at this, that before they enter large markets like the US, they've got their patents filed, they've got a long record of protecting their IP, they've then built their product as the second thing, not the first thing. So that's the bad. OpenEck got caught in patent litigation. The good is we survived it. The patents weren't specifically reading onto our software. But what it was is a wake-up call. So we started our patent strategy while the town is being shelled. 40, there's another gentleman in the room here who's over 60, working for OpenEck, to having the type of artillery that if anyone comes near us again, we're painted red, like nature's way of saying, stay away from us, you're red. And if anyone takes a pop at you, then put those patents back in the drawer, or we'll take out ours, because right now I'm not aware you're infringing those. But if you are, if I start looking at it, maybe I'll draw that conclusion. So as you get larger and you scale up, you must have your IP protected. You must have a practice within the business that is not an indulgence of the leadership team or of the CTO founder. It needs to be support the team. And this doesn't start of protection around the novelty of your idea. And when you get down to smaller vendors like us, my conclusion was, in the early days, there won't be any patents litigation in our area. Until you start taking the bread out of the mouth of an entitled large vendor, and if you're cheaper and you're more nimble and you've got better software, what happens then? Well, they run out of ideas and they start looking through their patent portfolio. And so things like this can happen. Our experiences was 7.5-year patent litigation, $11.5 million of expense. I could have taken it into a bucket in the car park and burned $11.5 million, and I would have pretty much got the same thing, which is nothing, right? So you get the right to exist by defending a litigation like that. Now, if we had filed patents earlier, which, again, I run a startup mentoring program called Mentoring for Scale. All of the companies that come there hear me talk about, if you don't protect your idea, the light in my head is already going off around the capability of your company to ultimately proceed. Because we've got EI making it super clear we must have a patent strategy, because we can build stuff, and then we can get into actually building the software later. And the residual value for patents is much bigger and longer as a baseline than software itself. We've protected ideas, and then we've had a product, in one particular smaller product, that was not successful in the market, but the patents we have are excellent. So if anyone else is successful, we're going to make money there. Now, when you have an arsenal, and if you look at some of the larger nations on the planet, when you have a large army, you tend to end up using it. So one of the things I moderate myself with is, I know what it's like to be attacked. We've been involved in a European Patent Office trial, a trial in the Eastern District of Virginia right beside the Pentagon, and we've had competitors actively interfere with the filing of our patents as well. We've had customers patent our ideas, so we've had to run an interference mechanism on them. If you don't, we've had employees sign away our IP. If you don't think this won't happen to you, as soon as you start getting big, it'll definitely happen. There will be free-form, open innovation jazz discussions where you end up looking at each other and you go, I think we just invented something here. We actually cannot patent this now. As I'm sitting here with a partner, they're co-inventors at this point. So we get very determined to not patent ideas as a result of a great meeting with our partners. I hate great meetings. I like to anticipate in advance what we're going to talk to them about, have the idea protected, and feel much better in the meetings that we have anticipated. Yeah, we were probably going to do this. This thing was probably going to come out. The great thing is we filed a patent on this last month. We didn't invent it with you guys right here. You might think we did. We've actually got this. So it gets, the last point, it gets to the point where you don't use your patent portfolio as a weapon because it is super expensive. Starting patent wars, the starter normally loses, in my worldview. You get to damage companies, drill a hole into their petrol tank and watch them drive around bleeding cash, as we did in our case. But if you start it, you have to be able to finish it. And in many cases, these things just go on and on and on, and the lawyers get wealthy. So what I see our patent portfolio is dissuading companies from taking a pop at us and actually using it for what it is meant to be, the accumulation and protection of the novelty of a company that's inventing into an area that is undiscovered country. And 5G is undiscovered country. We're making it up as we go along. The standards and so forth are only general. So that's, I guess, the lesson from the grave, that do not patent your stuff. Standing on the steps, and I was explaining to my daughter, this was his IP because he did the steps to a church down in Kilkenny in 1930. There's nothing left for me. Like years from now, there won't be any of my software left. It'll all have been replaced. But it isn't like it's not valuable. It's material. It's not physical, but it is where the world is going. It's not about steps anymore. It's not about physical. It's about protecting the novelty, the inventiveness. And Ireland's accumulation of medium-sized companies is going to be very dependent on those, A, not selling these companies, and B, accumulating, protecting the IP so that other companies don't take it from us. And as a last resort, you take a pop at someone to go protect your IP, but it is absolutely not to go around suing people. If you think it's that, that's a problem. Thank you.
One of the things is, this is an IP.
Go back, but it wasn't that obvious back in 2019. And so when you write your claims and you're building your patent portfolio, that you certainly, if you're not doing that, you don't get the benefit for that stumbling into some innovative areas that become important later.
The other point I'd like to make is do patent searching, patent landscaping before you start making things, because it gives you a better chance of finding this undiscovered country where the value actually lies. So, I mean, as a patent attorney, and I'm sure for every other patent attorney out there, we've all had someone come in for no reason. So it's important to find a valuable area before you actually build in potentially a dead space.
Possibly important for you not to do it, but to get your lawyers to do it, unless you want to be putting your hand on the Bible and saying, I have not seen this patent before. Really?
Correct.
Are you sure you haven't? Because we saw you searched through 500 patents back in the day. Are you sure you didn't see this one? I have been that guy. Fortunately, because I'm paranoid, I kept every email I ever had. And that's good and bad. So get your lawyers to do it. You haven't seen it.
One observation as well, Joe, I know you're involved in software, and there's a number of people, because I spoke at the coffee break, we're meeting up people this morning, there's a few people involved in software, and a lot of people think that software is not patentable. So what do people who are involved with software, how can they protect what they're doing and build an IP strategy around this? Maybe Yari, you have something to say on that.
Yes, well, software can be patented, that's the short answer. And I'm sure in the room there's a lot more detailed expertise how to do this. But the way I look at it is like it is a process, kind of to demonstrate infringement and to really analyze what there's on your system. So if it is so difficult, then why do you open it up for them in the form of a patent description? So I think for an SME, especially a startup, your ability to enforce, and I think that is another difficult question. But I think if you are wondering if you have software you developed yourself, get advice. That's my advice. That's what we did, and that's how we got onto that route. yeah, but software is not a. It has its own characteristics, but it is not black magic. It is doable.
Yeah, one of the things also I took a note from the presentations, and one of the quotation head was staff or knowledge engines. So maybe Paul, what do you think about how are not important? How can you encourage them to come forward, and are there ways?
I'm almost hesitant to speak with such great speakers around me, but just from my own background. So that when you're doing your JIRA cards, and we try to do that so to make everything predictable, like we don't solve the problems over and over again. But what that does is it builds a base of knowledge in the business. And so when you start getting that discipline, you're already in the review process. So that's just putting in the culture of good note taking, and then what we did, and we're going to try and see was there anything interesting here. And that's again a process. It's just doing it as a part. It's not like our IP development process. It's a part of our process. It's how we do business, how we are. So that was interesting, and maybe this is I don't even know if this is a real point. This is what I really do. So I think it's really hard to have IPR unless you're somewhere interesting. So as a business, you tend to gravitate to where you know there's budgets and you know that there's like competitive advantages potentially to be had, and you will tend to drift away a little bit from doing things that are edgier, edge cases, non-on-target customers, things that usually, the first thing a consultant tells you, stop doing that because you need to focus everything. But you need some requisite diversity of what you're doing, and unless you're working on interesting projects and your technical people are working on technically difficult things to achieve, you're not going to be in IPR land. So I think there's a tension between being practical, pragmatic, and focused about delivering business and doing that, and then bid. And it was like, nope. No. Actually, this bit up here, this corner, that's the thing. That's where your IPR is likely to come from. And I kind of thought about it like Starship Enterprise going into space. Like you don't know where you're going to find the interesting things. So what vector do you go on? So even just finding the right vector to be on where there's likely to be IPR, I think is a huge step forward for companies at our stage.
Yes, and when we're talking about patents, novelty is really important. So you're only going to get novelty where there's going to be an edge, where it's something different from what other people have been doing. So if you're talking about an inventive step, it has to be something which is something that other people haven't done. You're looking at problems, you're looking at what was hard about doing something, and how did you approach it that nobody else thought of approaching it. You were saying, Joe, about kind of looking over the horizon, so I think that you'd agree with that.
Yeah, so where I talk to my team is that it's 3 horizons. So on Earth, the Earth curves at 22 miles. If you're in a rowboat, you will not see the rowboat 23 miles away. So I look at IP as something 80 miles away, that you don't know which direction the next buying cycle or the next important. You might be in the 5GC, as I am. What's really going to end up being valuable IP versus, well, lots of people solved that, it was straightforward. There wasn't really a driver of IP. So we look at novelty at 80 miles. We start thinking about patents. There's patents. There would be, and it used to be quite formal, now it's down to essentially 3 of us to decide whether we will invest in that IP because we're doing it so many years. We have that patent written at 70. You'll be disappointed to see we filed a patent 2.5 years ago on this. So it's that kind of, it's rotating towards you. You can't stop some of these business areas coming, and if you are in those areas, you have to be really determined to drive out to locate and drive out the innovation. Now, one thing is the novelty could be quite small. So you've got a wing nut on an engine, but if that's the only type of wing nut that's going to work in this type of engine, then you have something. So, it doesn't have to be a broad patent with 500 claims in it. It could be a relatively narrow patent that has protected something.
Can I throw that to the audience? Does anybody have any questions they'd like to ask the panel? Do we see, has anybody any questions? Okay, I see a hand. So if you can identify yourself, your name and where you're from, please.
Yeah, Pat Breslin from Breslin Consulting. Very enjoyable discussion, so thank you all for the insights. One thing that's coming across, and I think you're touching on it, but there is a tension between discovery by doing and inventing before doing. So the fact that developing the product or the service that and build an IP portfolio, but even if we're not the ones successfully commercializing it, we got to know what it means to commercialize it and to create a product. So,
I suppose the first point on that is that one of the weird things, if you're doing intellectual property before you're developing your product, it's an inventive stumble. You don't have to actually move forward very far at all. You just have to, it's a legal threshold, it's a legal test. In fact, some of the stuff that gets patented in retrospect looks dumb, but it passed the legal test. And it could be the thing that has value. So it's almost,
You generally hear from staff that they don't believe they've invented it, that there is no invention. And it's not that they're being resisting, it's that they sincerely don't think. So your IP team has to work with them to pull it out of them, because when you go through, it's like, well, you know, when did we solve that? When was this resolved as the only way to do it? Is this the only way to do it? So that's one thing that you must have engagement with staff. It's not waiting for staff or engineers to come up and say, look, I've invented something that you've got to be going to. And reminding them that would be almost a quota to make here. There's an expectation, but there's no way we're not. It's just the fact that you just haven't articulated it. We've got one that has 8 other patents around it. So you don't have to be going, give me a different widget now, a different novelty. But no, it's a novelty with a continuance that has a further refinement. And when I look at that particular cluster, we've had several have gone, well, that diluted with this added to that, and every other variant around it leaves you with. I look at it like, if you're a business entering a field and there's an oak tree, I can see that patent, see that oak tree, I can invent around it so I don't infringe the patent. Let's say you transit through a field where there's bamboo sticks everywhere, 100 of them. You cannot slow down because your business, you're employing, you're trading. Now you've got to get around how many patents? You're going to clip one of the patents, one of the claims on one of the patents. So if you've got something, you can densify it, but it's broad enough that you've got enough to protect the area. So it doesn't have to be individual point inventions. It could be continuance of parts, and the protection of the whole field.
Also, when we're talking about trade secrets, you can be looking at copyright. I really did like when Paul, when you're telling your story and you're starting off, you think about what are you going to call the company? And you talk about Web.io. So that was one part of it. But also coming up with terms like conversational middleware. So you own these kind of terms and this branding around this. And this branding is an extra part of your IP strategy that when you put it all together, that there's a huge value for the intangible value of the company.
And so absolutely. And besides the fact that you've got integrity as a brand and you stand for something, people kind of go, oh, I got you, I know what you're about. And getting to that very quickly is really important. It's just the simple world we live in. When people get more and more, if you're looking at software companies at our kind of level, they're machines for finding customers. It's like, so how do I find customers and how do I supply my product very quickly, self-service, and they're very well-known metrics now. So almost you have to fit a pattern. You're going to miss the rest of your metrics.
Okay, thank you. The panel are still going to be around afterwards, so I'm very happy that you can have you can approach people and ask questions afterwards. You were saying, Joe, about this being the lessons from the grave. I'm glad that it isn't from the grave, actually, and that you've actually learned from the battlefield rather than from the grave.
Well, we certainly thought it wasn't the grave when it started. We couldn't afford it. But then it's useful to have belligerent, stubborn investors and staff.
Yes.
We're just not getting pulled down by this.
And take it internally.
It's a trial. You know, a lot of these times they're not necessarily, I would say they're commercial tactics.
Yes. And when I started off, I was talking about Achilles. And one of the things that I always made me puzzled about the Achilles story was how random it was that he got an arrow in his heel. And it seemed like a very uncool way to die. So when we talk about stories from the grave, and then I went back and I researched it, and it isn't in Homer's Iliad, but actually in some of the writings on Achilles, they say the reason that the arrow was fired to his heel wasn't a random shot. It was Paris was guided by the god Apollo, who said, shoot for his heel. And in the world of intellectual property, very often you're not getting killed by a random shot. People know what they're looking for, they know what they're going to target, and they're going to come after you. So you really need to have an IP strategy that is based on the fact that a lot of people out there are very sophisticated, they're going to be coming after you, and you're going to need to have a strategy in place. I'd like to thank my panel for really great insights here. So I want to thank Richard Gillespie, Joe, all the other presentations. Thank you very much.
Thank you very much, guys. A very interesting conversation. And I have to say, it echoes a lot of what I hear in my job on a daily basis. I remember the first time I met Paul, he was starting talking about this conversational middleware. And I nodded along as if everybody knows what that is. Now I know he just meant, and they're all doing something that's potentially got intellectual property. But they all say they have.
We'll start at the European office. We'll start off slowly and we're going to build up quickly. We'll be talking almost exclusively about computer-related inventions, particularly about artificial intelligence, machine learning. So there's just a quick show of hands. How many people here are currently involved with directly or through research? So who's not currently working, expects to be working with AI and ML in 5-6 years' time? And we're seeing a few. So we're taking us almost up to 3/4 of the people here. Some definitions, because this is always a good one, will operate. Now, good for us, the European Patent Office examines, even though it's relatively recent, artificial intelligence and machine learning patent applications as computer-implemented inventions. So the question is, how do they do that? Now, thankfully, it's very, very well established. So there's an important case that is referred to the Enlarged Board of Appeal. This is the case of G308, and that dates back to 2010. And whilst ultimately the referral was deemed inadmissible, the Enlarged Board did provide us with 55 pages of opinion of how computer-implemented inventions should be examined. So today, the case law of the Boards of Appeal, this is effectively the judiciary that oversees decisions and can give for, give against at the European Patent Office. Whilst the corpus of these decisions is relatively limited on AML, it's relatively large for computer-implemented inventions. Now, of course, computer-implemented inventions are only part of what the European Patent Office does. Over here, we have a huge corpus of case law, particularly, and I'm going to talk about this later, chemistry, for example. What we have with computer-implemented inventions is a so-called two-hurdle approach. We have a very low hurdle, first hurdle, to overcome. If your invention has something that has technical character, and this can be as simple as you run a method on a computer, you pass the first hurdle, very low hurdle. The second hurdle is probably as high as the first hurdle is low. And now we're having to see what technical problem is being solved, how is this technical problem being solved, what is the technical effect, only by the subject matter that is technical in nature. Now, the great thing about the EPO is ML. Very usefully, and the European Patent Office is forward-thinking. Last year they had a conference around this time last year on patenting artificial intelligence, but they followed this up with revisions to their guidelines for examination. And this is what the examiners of the European Patent Office follow, and also the opposition divisions, should you ever get there. Importantly, they included in that November 2018 edition very useful, very illustrative examples of how AI and ML inventions should be examined. Now, an important part of this was looking at mathematical methods. Now, a mathematical method as such is excluded from patentability before the EPO, along with, say, business methods and mental acts. However, what they have acknowledged is that a mathematical method, which per se cannot be patented, can contribute to technical character if it does one of two things. Either you're applying it in a field of technology, or it's being adapted for a specific implementation. And that's pretty much what all of you who are working with AML will actually be doing. So that's good news. So then what we see is that you can really categorize inventions that are based on AML as to whether they're patentable or not. So we can have core AI inventions, which relate to fundamental algorithms. These will be excluded unless we now either apply to a field of technology or we have a particular technical implementation. What this extends to is that we can actually, in Europe, is a very well established, some 9 years of continuity, knowing what, if your patent application is being examined today, we can pretty much forecast what the outcome will be. And the same will go for opposition or even something an appeal before the technical boards. So very well established what we do today in Europe. What about at the USPTO, the US Patent and Trademark Office? Well, there was a time in the US when you could patent pretty much anything under the sun. Now, for computer implemented inventions, that all changed in 2014 with the US Supreme Court decision of Alice, and looking at patent eligible subject matter, the same as excluded subject matter in Europe. And that really pretty much sent US attorneys scrambling to work out what to do with all these pending patent applications for computer implemented inventions. So the US is also very progressive, and they have a new director. And earlier this year, in January, they released new guidance on patent eligible subject matter, specifically looking at computer implemented inventions and also bringing up new examples. And what they've done is present what they call a two-prong test. Not that dissimilar, I think, to be able to get a patent for in the US. Here, what we're doing is we're training a neural network. Okay, that's what we're doing. So you can have a trained model in Europe. In the US, it's quite similar. You can have you can actually have a method of training a neural network. So the US then is also looking a bit further forward, perhaps thinking that the decision in Alice, as it was in 2014, went a little bit too far, that there's a bit too much of a knee-jerk reaction. The new director is pushing to say that the courts have gone too far, and there's a bipartisan group looking at reform in high areas of artificial intelligence, medical diagnostics, and personalized medicine, for example. So the US is advancing, but still we have pretty stable framework for examining patent applications in the US as much as we do in Europe. The question now is, what happens when we start to look towards the future? So Joe was talking about when you're inventing, going to be examined according to the guidelines that are current today. They're going to be the guidelines that are current in 5 years, 7 years, 9 years' time. That's when it will be examined, that's when it could be opposed, that's when it could go before the Board of Appeals. The invention, the application, is it described in a manner that is sufficiently clear and complete for it to be carried out by a person skilled in the art? That is, can I reproduce what you have described in your patent application? This is common for those working in particularly chemical, pharmaceutical fields, but not so much those who are working in engineering or get onto that. So what does sufficiency require before the European Patent Office? And this is the killer here, this is perhaps the Achilles heel for a patent application. You cannot remedy sufficiency after the date of filing. If it is not inherent, you can't correct it. That means that your patent application may be refused, or you have this in quite some detail. Now, the Neural Information Processing System Conference is perhaps the largest and certainly oldest, dates back to the 1980s. Last year, there was some 8,000. I'm so concerned about reproducing what's in these papers and posters that they now have an analysis of complexity, and then this new one that you might find too onerous, a link to downloadable source code. Until you see a big reproducibility checklist for figures and tables, basically results. If you're presenting any results in your patent, they want all of this. And if you follow through, you'll find that, oh, we want to have a link to a downloadable version of your data set. And someone will be thinking, I know who is active in the field of AI and ML. He shared it with me. So this is why we're thinking towards the future. But we're not in between the training data set, something in your training data, and the result. Or if you can't, are unable to, because you must present test results that show the effect that you're working towards, that you are claiming is the result of your claimed subject matter. So how do you address this requirement in Japan? And why do you think that this requirement in Japan that was designed for academics but has a lot of teeth for those who are working with patents? Scientific examples and parameter ranges to say where you come from when you're talking about computer implemented inventions. So what I'm saying is that when you are preparing, when you are working with an attorney for your application with the data, and this is what you have to extract through. So, as a very brief summary, a potential problem, looking out into the horizon now, today, how to get a patent application granted or to maintain a patent, stop it being revoked, because the guidelines and the case law is very well established what could happen in the future. And the signposts are that we're going to have to address this important topic of sufficiency. I don't have time, and I could talk just as much about the question of plausibility. I'm happy to take questions about that afterwards in the discussion. So thank you very much indeed.
So thank you, Howard. Very interesting, and that highlights the level of complexity that's emerging both for companies and for the wider system in the in the IP world and in companies developing technologies and so on. I think the takeaway for me from that is seek advice. Get a good advisor early. Maybe some people haven't got their badges yet, that they're available for you at the registration desk. So I think we all deserve a cup of coffee. I know I feel like one.
Sorry? Yeah, I will also do yesterday morning, and of course since then we've been trying to make sure that everything.
All fueled up on caffeine. So I want to introduce the next panel session, which is one very close to my own heart, I have to admit, because this is the world this is technical for SMEs. So this is an increasingly important subject, and it's the world that I lived in.
Up here actually aspire to be where the last speakers are. So, and where we're agenda at the moment. And then we have Patrick from Croon Precision Medical, and Patrick, I suppose, has a background. In 2010, we took a strategic decision that we, I think it's 17 EU-funded research. 3 questions on IP. What was our plans in terms of our IP? How would we plan plus strategy development? So I think I've well and said my bit at this point.
Science and product development for the world's largest mushroom producing mushrooms. If you go into superbugs now, setting it as a work package, any product, if you're developers. If intellectual property in the IP Plus programs. I'm happy to address questions. Thank you.
This is quite insightful. Hi, my name is Dr. Shaurya Sanya. I'm the CEO and they're now taking over the hospital ecosystem by bringing care at the patient's home. But what they measures biometric parameters like heart rate variability, respiratory rate, blood oxygen saturation. In the world, we're seeking FDA approval for all the 3 platforms as well as medical device. This is primarily different through a law firm in the UK, and that was the thing. And the studies that was written about leadership is the leadership team needs to understand IP strategy, which is building a roof of when people decides to acquire you, they buy you as a multiplier of your sales, right? 2 cents on IP. Thank you.
Thank you very much.
Just a small bit of content. We're an SME company based in rural Limerick, in business 35 years, and essentially our own initiative, our own because it's a very exciting place to be. It's a very and every conference and every initiative ideas. I especially learned the comment this morning. I like the comment word by
throughout the session as they come up. Or short, so we have extra time for questions. No pressure, guys. Our IP is actually at a senior level at board meetings and
has a different approach, but fundamentally from a skill set point of view, take the first draft to the second. Give me some sort of EI funding or any type of government funding to correctly the first time, because if you mess it up the first time, it's really difficult and you're wasting
the IP portfolio. So it was as important as that. Yeah.
sorry, we have a question.
I have a question on the funds, and it's not fun patent if the patent in the next year you have to follow it to court and stage
due diligence versus I really like you, I really like your idea. Spin-outs get really big funding because they have a strong IP. And I know a bunch of companies that in the last, I was in the US for a couple of months, and product is going to stand out. About $1 million investment from New York State last month to build a new product. So,
and to defend it, what would be the point? When we actually developed the technology, we had to kind of take a bit of a stand back and say, oh, we can't afford to if someone does actually given an interview.
So depending on the nature of your company, the stage of development that you're at, you're going to be looking at different companies need to be more confident and more in how they present. The only one up here with a guaranteed salary, right? but I have some experience of the other side of the fence as well. And
because if you're in a good position, you may find a solid position, whether or not the guy or girl says to you on the other side of the table that they back it, they are ticking that box from the start. That's great. But sometimes
and then get that going and then come back to, as you said, to IP. But sometimes when you're a very technical company that you're building.
And if anyone wants to ask specific questions afterwards, but we'll time for one or two more.
I'm Bhargav Patel. I'm a biotech specialist. So the question market is, could be 10, 15 years. Can you reflect on your experiences or awareness of a conflict with the need to have an in-force patent once the product gets to the market? So the continuous development of new technology.
In the next foreseeable future, 4 to 5 years. So we are pursuing aggressive growth. So we put in a lot of money for handling is when you raise money, understand the VC probably, if it's a VC, has a $100 million fund, right? So he doesn't want all of the investments to make bank. So he wants 1 or 2 of them to make a growth, and as that, you have to put in a lot of money for ensuring the IPs don't slip through.
Say that every company has to have their own internal IP department. The important thing is that you have an IP strategy, and how you go about that, it may involve, as people brought up. I just want to add to what SJ said. You mentioned about increasing your valuation and going from a 3 times multiple to a 5 to 8 times multiple. The advantage of having strategy is you get away from actually having the multiple discussions. You can, because
back at home, and I'm definitely starting to see big numbers coming up now, and looking forward to a very happy retirement when we get this portfolio sold off. And thank you very much for engaging with us. And
only one of those companies was Dublin based. All the other companies are employing people in outside the strategy, which is something I'd really be interested to hear about from Zeev Fisher. Thank you very much. So, yeah, I'd like to relate to that. I'm not from Dublin. So I have a brother who realized that the politics in Israel committed a suicide. But yeah, really, nobody wakes up in the morning thinking of any of these things. You know, we don't wake up thinking about tech. We don't wake up thinking about IP. It's really not.
it's really not that important. We wake up thinking about other things. Some of them are quite common between us, and this is sort of an existential thing. I'm approaching 40, so I'm allowed. And some of it is really weird. People are weird. Interesting one. So who's not with one of the traditional banks, with a new bank? What, you don't have them in Ireland? I am, and apparently, so I use Revolut, which was a former client as well, but it's doing very well. I mean, have you heard of Revolut? Nobody's using Facebook anymore. But Jed explained to me that now Monzo is super popular with his generations. They have this very orangey.
Wow. Are you ready to pass it around?
This is the reason. That's what people care about. And I was trying to understand whether it has a particular functionality. We'll try to tell some story. And there's a fascinating book, Sapiens, on about half attorneys, half entrepreneurs, and but really we wake up in the morning and we either think about things, and I'll touch on where tech, but it's really about strategy. In Picama, everyone needs an IP strategy, and so on. There's the offensive bit, like what do we do with competitors? The things that SMEs tend to completely ignore. But as I say, rightfully so, at least in some industries, but maybe not. And this is an IP strategy talk as well when we look at company strategy. So first of all applications are assigned, and they're assigned to the right entity, and the entity name is consistency. So these sort of things. The first two bits, this can be automated using tech. The main thing really is to identify IP when it happens, and the best thing to do that is by and then where do you file the first application? Wherever their outside counsel's policy is to file, and they never think about that it takes 5 years to get a patent. No, it doesn't. It can take a year and a half to get a patent. All you need to do is ask, but you need to know that you can ask. IP strategy, because I want to show you some tech bits, but you can do quite a lot. Yeah, so IP is a very competitive market, actually. Both in the firm that you would ever do are extremely competitive things. I mean, there are thousands of firms in China, thousands, literally. There are thousands of firms in everywhere, really. It's a super competitive market. Yet, I'll have to go beyond a bit. It's a super competitive market for free. But also, I'm having one of these.
But around primarily revenues of IP to investors. Isn't an investor
and I suppose we become coming to the understanding that we have a quality system around products that's pretty standard. Everybody will hear about finance to make sure that the money isn't going astray. We have one around the people to make sure the people are well protected. Now we're building one around the knowledge and the IP, and it is of equal value. So the building of that infrastructure is something that, and that architecture is something that we're engaged in at the moment. I think it was Joe mentioned how important it was before you to have that planning and that architecture in place before you start putting in packaging. Also, the business that we're in, as I said, we're farmer owned. We're principally owned by dairy farmers. So the worries and concerns of dairy farmers are our concerns. Our business, I said we're about reducing cost. Some people mistake that with price. It's not, it's cost. And there are a number of costs in there, one of which is environmental. And for dairy farmers, environmental cost of dairy farming is a very significant issue. It's all the innovation challenge.
Looked because intellectual property comes in multiple forms. They're all valuable.
In the area, it's but it's valuable. And that's there's some of the keys we look at. Hard value. And in there, maybe
principle that applies when you're getting up on a panel is you look at the topic they're going to be talking on and you make sure that you know a very, very well written entry on patent valuation, and it does discuss, as has already been described, the three principal methodologies. You know, when we talked about it before, I guess I had a particular view, and then Donald shared his. You can't really talk about patent valuation without actually talking about why you need valuation. And you may find that depending on the context, one method may be more or less preferable than others. So, for example, Donald was talking about the cost-based approach. I mean, in an M&A context, I would imagine perhaps very reproducible and predictable methodology. So if you're looking for a valuation for, let's say, in accounting purposes or something else to shoot back at his competitor, you probably would have paid, I'm not putting words in your mouth, and you know, in that context, yeah, if we go back, market comparators is, you know, from an economist's perspective, as I understand it, not being one, that's a nice approach to be able to use, but unfortunately the IP market is very, you know, if your IP strategy includes a licensing element, then you know, an income-based approach may be something that you're looking at anyway. But I think, you know, both with that Paul and Joe were talking about earlier on, where you've actually put thought into your development of your IP portfolio before you've actually gone out and acquired it. I think you probably already have quite a good insight than, you know, some M&A expert who's coming in cold and trying to apply from a very sort of mathematical perspective one of these three measures that we're talking about. So yeah, I think context is important. The knowledge that you already have been generating yourself, that's important too. And then, you know, depending on what you want valuation for, I think you may tend towards one or other of the approaches.
I think I'd add to that. You know, we talked earlier about, I think yesterday mentioned about multiples and so on. And you know, if you're valuing a company, there are 3 or 4 or 5 or quite a number of methods that you want to use for valuing a company, and they all give you a different answer. So which one do you go with? And in the end, you go with what is it for you? What's the value to you? What's the context of that organisation? And the fact is that the value, which one does the seller want to sell it to? That's their decision then, but just know the value to yourself. So the methods, probably the 3 methods that are there, that are you know, that have been spoken about, but it's some blend of those.
Expert, because that's exactly the right approach from my perspective, is that if you can corroborate the results using multiple methods, or even with the same method using multiple comparable observations, the arm's length value. If there are multiple bidders and you're the seller, you're in good stead, because then you get to pick the highest or the best partner. In the valuation or economic and finance, it's similar to filing for IP or further developing IP, like Nisha's described on those, to secure your own judgment in the present, to decision.
Yes, because we're an SME, our resources are limited. Maybe they are not organisations in the end, but as a result of IP we have. So, you know, one of the questions there was, do we try and sell the product ourselves, or do we license it out? The IP is, we license it where to gain the brand building and knowledge. But we'd see that as the licensing, the royalties for a continuing basis from the IP as an important area. We also use it to build our own brand in markets where we're going to be active ourselves. And to build again reputation and around that, our knowledge and what's behind us.
Probably called, in some respects, more sophisticated, certainly more complex. Like Donald has described, not just licensing, let's say, portfolio, but the ability to take the prototype that they've developed and actually to you know, the variety,
the ability of the company to trade, the ability of the company to attract others in. So then we can build the architecture and the IP architecture around that, so that we're safe and that we're building an ability to trade.
The different potential revenue streams or different positive outcomes that could arise do make IP more valuable. That would be option value. It's not a one-trick pony. Companies have to morph. Recommending music was the best application of that. And then we realized that actually there's not going to be any digital music licensing at all unless people can manage copyrights. So we developed music identification technology so that we could hopefully later do recommendation technology. But if this panel were to morph, or because as Donal and all of us are saying, there's the value in IP comes in many forms, and it can be strategic benefit, complementarity between assets and IP, and it's always elusive to value it. But like in the first slides, the long timeline, when we eventually got to this new era of blue spikes for intangibles and intellectual assets, that is where we are. It's not always going to be as easy to value as a cow or a car, but it's necessary. Those are the valuable assets in the commercial space. So I thought you wanted to
transfer. Do you have any comments on that?
Yeah. Well, my own view is that IP and other assets that operate collectively and are transacted collectively are reflected and as the know-how if it gets into other hands.
Arm of their business, they hold patents many. And that one of the reasons they patents are either currently in. So
I'm not sorry. I'm enforced. I'm not in my question. I should have clarified. I'm not enforced.
I think there's